Good evening, everyone. I'm Joan Carter, the chair of the Union League Legacy Foundation. It's my pleasure to welcome you here this evening to our public affairs program. The Legacy Foundation is the nonprofit charity of the Union League dedicated to preserving the individual freedom promised to us in our Constitution. Tonight, in the third of our series on COVID-19, we are going to hear about whether or not the government actually has the right to take away this freedom in the interest of keeping us safe. The Legacy Foundation has recently expanded its work to establish the Union League Employee Emergency Fund. As most of you know, the government has ordered the League to shut down, which means our employees are furloughed without pay, and the few who are working are doing so at 60% or less of their salary. So our people are struggling. I'm proud to say that the Union League members have raised over $575,000 so far, and my sincere gratitude to the many members who have contributed. We've sent out over 250 checks, and I want to read to you a short note of appreciation from one of our employees. My family and I are so blessed. The support came in the mail as a surprise, and it's left me speechless. I'm so grateful and proud to work at an establishment where its members care so much about its employees. It's amazing. Their generosity is appreciated, and we, my family, are very thankful. My unemployment claim is like the many others, still caught somewhere in the overwhelmed unemployment department pipeline. To receive unexpected relief at a time where the future is unknown and things seem very bleak leaves me at a loss for words. Thank you all so much. And I can't wait to get back to work and cook for you all again. And that, folks, is why we do it. I also want to thank our Legacy Foundation annual fund supporters, especially the Founders Circle and Lincoln Leaders. And now it is my pleasure to introduce the man for all seasons, the moderator of our program tonight, and the executive director of the Union League Legacy Foundation, John Miko.
Thank you, Joan, and welcome everyone to our third in our programs on COVID-19 and its impact on Philadelphia and the area. And this one's going to go much beyond that. I want to also thank our program committee and our program committee chair, Steve Target, and in particular, a member of that committee, Jason Rea. Jason, I know you have a lot of your colleagues and friends at the Freedoms Foundation watching this program tonight. The first line in the Union League bylaws is every member shall support the Constitution and the free enterprise system. And perhaps never before in the history of the United States have we had an attack on both the way we've had in the same way, the Constitution and free enterprise. So I think it's absolutely appropriate that we're talking about this tonight, and I look forward to a robust discussion on some of the very serious issues we have with civil liberties in this crisis. A few housekeeping items before we get into it. For those of you that are watching on Zoom, down at the bottom there is a Q&A button. I can see that already people are asking questions. That's great. You can ask questions throughout the program. We probably won't get to them until the end, and we'll get to as many as we can. If you're on YouTube, you cannot ask questions through the YouTube app. And of course, we can't see you, just so that's clear. You can see us, we cannot see you on Zoom or of course on YouTube itself. So let's meet our panelists, please.
So, John, I guess you want us to introduce ourselves?
No, I've got you, Jonathan.
Okay, good.
we have a fantastic group and I'll start with you, Jonathan. Jonathan Goldstein is a founding partner of Goldstein Law Partners located in suburban Philadelphia. Jonathan's practice focuses on entrepreneurial and business advising, among other things. He's a nationally recognized expert in firearms and election law and has published articles on firearms law and safety and election law. Jonathan is a great friend of the Union League. He's been a part of our programs in the past, including a Liberty Series program on the Second Amendment in 2018. Michael Moreland, another great friend of the Union League and the Legacy Foundation, is the director of the Eleanor McCullen Center for Law, Religion, and Public Policy at the Charles Widger School of Law at Villanova University. Professor Moreland's a scholar of constitutional law towards bioethics and religious freedom, and is frequently sought for commentary at conferences and media and before Congress. He's published articles in leading legal, public policy, and medical journals. And again, Michael's been very involved in many of our programs throughout the years, including he was the moderator in our program with Jonathan on the Second Amendment, and he also interviewed Justice Samuel Alito in one of our Liberty Series programs. And David Hudson is a visiting associate professor of legal practice and teaches legal information and communication at Belmont University in Nashville, Tennessee. He's an author, co-author, or co-editor of more than 40 books. For much of his career, he's worked on First Amendment issues. He's a First Amendment fellow at the Freedom Forum Institute and serves as Justice Robert H. Jackson Legal Fellow at the Foundation for Individual Rights and Education, or FIRE. FIRE is a wonderful organization based here in Philadelphia that the Legacy Foundation has worked with for many years. Gentlemen, welcome. Thank you for being with us today. So I thought we have a lot to talk about, but I wanted to give everyone an opportunity to kind of get some context here. And I'm going to ask Michael to give us that context by way of a bit of a con law 101 with regard to the issue at hand, which is individual liberties in the time of crisis. So Michael, if you would give us both that con law 101, and a little bit of federalism, a little bit of police powers, and a bit of what has happened in our constitutional history when we've had these crises and civil liberties have been amended, if you will. So Michael, if you would, give us a little bit of that history.
Sure. Well, thank you, John, and thank you, Joan, and to the staff of the Legacy Foundation as well for putting all of this together. So I'll be, just as John said, give some very brief overview of some of the constitutional issues in play here. We might think of it as two of the big ones, separation of powers and federalism. So with regard to separation of powers, of course, the president has various powers that are enumerated in the Constitution. But he also has the powers that are granted by statute by Congress. And so a lot of what you're seeing at the level of the federal government are enactments going in some cases back many decades that set up the Department of Health and Human Services and the Food and Drug Administration, the Centers for Disease Control. And so a lot of these briefings at the White House and other settings, what you see are the power of the presidency being brought to bear with regard to treating the pandemic through those agencies, which again are created by congressional statute and have a broad delegation of power from Congress to regulate in ways to protect public health. All that said, there's no kind of general federal power, general kind of federal police power, as it were. There's no, the president overstated things a bit a few weeks ago when he said that all the authority is with the president of the United States. Because the federal government in the end, in the Constitution in Article 1, is set up as a government of enumerated and limited powers. And so it has to be acting, regulating, pursuant to one of those enumerated powers. And this gets into my second big issue that I wanted to talk about, which is federalism. So whereas the federal government is a government of limited and enumerated powers, the states have what we call in constitutional law police powers. And that doesn't mean the power of the people who ride around in cars with sirens. That means the general power of the states to regulate even beyond those limited and enumerated powers that limit the federal government. And of course, it's pursuant to those police powers that you see across the country these various shutdown orders and other kinds of restrictions placed on what kind of businesses can be open, what kinds of gatherings people can have, and so forth. And in all those instances, certainly true here in Pennsylvania and New Jersey, there are statutes that set forth the emergency powers of the governors of these states, and they tend to be quite broad, that if the governor declares an emergency, he has in these states powers to shut down businesses, restrict church services, and all those kinds of things that we've been seeing in the headlines. Now, of course, that though comes up against our civil liberties. And that's where you're seeing a lot of news right now. Even when the government is acting pursuant to these police powers, there are still limits on the ability of the government to do so that are protected by civil liberties that are enshrined either in the state or federal constitutions. And the most important case in that regard is a 1905 case, Jacobson versus Massachusetts, which involved a compulsory smallpox vaccination requirement, and against a challenge brought to that by someone who didn't want to be vaccinated. The Supreme Court in 1905 said that notwithstanding that in order to protect public health, the government still has powers to override personal liberties. A little quote from Jacobson, the court said, "In every well-ordered society charged with the duty of conserving the safety of all of its members, the rights of the individual in respect of his liberty may at times, under the pressure of great dangers, be subjected to such restraint to be enforced by reasonable regulations as the safety of the general public may demand." Now, of course, a lot of the issues that we're going to be talking about for the next 50 minutes or so are precisely around the questions of what are reasonable regulations. And we can talk in specificity about restrictions on free exercise of religion, freedom of speech, restrictions on businesses, takings of property, things like that. Second Amendment, my co-panelist Jonathan Goldstein is a great expert on that. And so that's kind of the contour of it, though, is what are the limits of these police powers of the states, which are very broad, particularly in times of emergency like this, but do have these limitations built up into them. And more we are seeing are some courts, even some legislatures in some instances, local governments, chafing under this, and what are the legal remedies that are available in that kind of landscape. So that's our general overview.
Thank you, Michael. Let me pose this. I want to read something from Evan Gerstmann, who wrote in Forbes magazine. He's a constitutional law scholar, and he was trying to look forward to what might happen when, and this was right in the beginning of all of the chaos and all of the government intervention. I just want to read this as kind of a jumping off point. The question was, what kinds of restrictions would not hold up from constitutional perspective? And the answer he gave was, I think he was being very conservative in his response, restrictions that smack of political favoritism would fail strict scrutiny, as well as hastily drafted laws that made distinctions between what sorts of activities are allowed that would not be justified on public health grounds. Also, laws that put people's lives or health in danger by over-restricting access to medicine and medical equipment, or perhaps even exercise for some people would probably be unconstitutional. So might restrictions that, for reasons of political inertia, remain in place after they are no longer reasonably justified. So, boy, what a great world he thought we would live through in these last 2 months. What happened to this strict scrutiny? What happened to some reason with regard to laws? Jonathan Goldstein, I know you're going to jump out of your shoes if I talk any longer. What are your thoughts, Jonathan?
Well, I'm so grateful for the opportunity to be here with you today, John, and I'm so honored to be on a panel with such distinguished scholars like Michael and David. I am a mere practicing lawyer. I am not a professor, so it is always fun to be on a panel with professors. Yeah, I mean, we've started to see courts parse some of the issues that were raised in that article. And I'll give you two examples. You had a case, I believe it was in Kentucky, where the governor and the enforcement authorities, under those broad powers that Michael referenced earlier, started to disfavor and treat under sort of a different set of rules religious practice. So I think there was an effort to have a church that where the members met in a parking lot in their cars and came to worship. And the governor threatened to shut that down. Well, the courts down there said, look, you can't do that. You can't single out religious practice for a separate treatment than you give to commercial establishments. In a state where you're allowing drive-through liquor stores and drive-through pharmacies and drive-through grocery stores and maybe even drive-through pot dispensaries, you can't say you can't have drive-through religious services. So you are seeing some courts rise to protect some of the more, what I'll say, easy to protect rights are the courts that, the rights that the Supreme Court has fallen in love with, traditionally First Amendment rights. Where it gets harder is where you see rights that the Supreme Court has traditionally been less in love with. Property rights and gun rights are two places where we've seen the courts a little more reluctant to step up. Here in Pennsylvania, our own state Supreme Court was reluctant to do the right thing by gun stores. Ultimately, the governor backed away when he saw that we would be headed into federal court on that issue. And certainly with regard to property rights, the Supreme Court has made a bit of a hash of that area of law, and we see much less protection around core property rights than we do around things like First Amendment religious practice.
So Jonathan, let's stick with First Amendment for a moment, though, and I'm going to ask David, because David, I think you actually were involved or wrote about the situation in Kentucky, and I know you've been involved in some other cases. Where do you see the First Amendment rights kind of maybe going a little crazy here on the COVID crisis, and what other things have you seen?
Well, what I think we've seen is we've seen a bit of the adulteration of the strict scrutiny standard of review. You know, traditionally it's been sort of strict in theory, fatal in fact, or in the words of, I think, Justice David Souter, quote, strict scrutiny leaves few survivors. There have been different approaches that courts have taken with regard to strict scrutiny. One approach that Judge Bernal took in Gish versus Newsom out in California is he said, well, there's just an absolute emergency exception to the Constitution. And when you have an emergency, constitutional rights take a back seat, blah, blah, blah. What some other courts have done is they have applied the first prong of strict scrutiny. So there's two prongs of strict scrutiny, which is the highest form of judicial review, right? Does the government have a compelling governmental interest? Most courts have said, yes, clearly there's a compelling governmental interest, but it's that second prong of strict scrutiny that I think is sometimes being ignored, in that it's either supposed to be extremely narrowly tailored, or the so-called least restrictive means test is another iteration of the second prong of strict scrutiny. And so I think what has happened, at least in some cases, is that the courts have found that, in other words, they have found that there is narrow tailoring when there really isn't. The nice thing, as Jonathan said, in that Kentucky case, On Fire Christian Center versus Fisher, on April 11th, 2020, federal district court judge there said, look, you cannot have abject differential treatment of religious groups. Just as Jonathan said, right, when you allow drive-in liquor stores, how can we say that something's narrowly tailored when you're absolutely discriminating against religious entities? I thought that was a good example of a court applying a version of strict scrutiny. But what this could mean is that we could see an adulteration of the strict scrutiny standard of review, and greater deference to government officials. And the precedent that's established here may be used in future times.
I mean, John, I think David's onto something, right? Which is that when you have a crisis like we have, and it's a genuine crisis, and in the pleadings we filed, we acknowledge it. We acknowledge the governor has to have the authority to manage a crisis like that. But you get a lot of judicial deference to the executive when managing a crisis like this. And, you know, certainly at first, and again, here we're instructed by some of what we've seen coming out of courts. The Texas Supreme Court had a case where people were challenging various aspects of the COVID closures down there. And one of the things they said, which I thought was instructive, is this, quote, as more becomes known about the threat and about the less restrictive, more targeted ways to respond to it, continued burdens on constitutional liberties may not survive judicial scrutiny. And one commentator on that summed that up by saying measures that were constitutionally proper in March and April may be less proper in May and June. So, you know, you're seeing a lot of that deference. Hopefully we don't see our entire jurisprudence kind of run to ground the way that David posits it could be in this environment. But it is time for courts very soon, if the moment hasn't already passed, to get a little more muscular in protecting some of these rights that have been just, sort of deferred, where there's been executive deference given in the early stages of this crisis.
So, Michael, let me ask you, have you seen any evidence that that is happening? Do we see any courts that are beginning to overturn or side on the civil liberties side of this issue that maybe wouldn't have 2 months ago?
Mostly in the free exercise of religion context. David mentioned the case arising out of Louisville. The Circuit Court of Appeals out there has also weighed in on the issue. And so on that score, what you've seen is courts engaging in a little more scrutiny about what I'd say the sort of the problem of fit here. That is, say that whatever restrictions the government is imposing have to have a reasonable fit with the danger that the government is addressing. And so in instances where you allow a wide variety of different kinds of gatherings, but you say, but we won't allow it for exercise of religion, that starts to look like a problem. But of course, in other contexts, say, for example, allowing grocery stores to be open, but forcing restaurants to close, you say, well, there the fit makes a little more sense, right? That people dining in restaurants, given what we know about the virus and so forth, that poses a risk. That people stopping quickly at a grocery store doesn't. And furthermore, obviously you have to have the grocery stores open so people can get food. So that's where I think we're going to start seeing more and more of the inquiry, though, is how restrictive or in other instances, under inclusive is the government in the kinds of regulation that it's imposing relative to the danger that is posed by the virus. And this, of course, is why you're also, I think, starting to see, even in Pennsylvania here, some variation from county to county. So the state government, without being forced to by courts, is saying, you know, in some counties, the risk is relatively low, so we can allow some things to start reopening. But in other counties, like here in Philadelphia and the collar suburban counties, less so.
So you just used some reasoning there. And you actually said there's some reasoning happening in Pennsylvania now, which is delightful to hear. David, you've actually been involved in some of these Pennsylvania cases. You've been following them. Jonathan, you've been in the middle of them, and a lot of them about property rights. So let's go there, Jonathan. We've had a really interesting, especially in Pennsylvania, I think more so than in a lot of other states, restrictions that seem to we're going to have them for a long time if we listen to our governor and what he's saying. Jonathan, what have you been seeing, and is this reasonable, what's been happening?
So I think you're seeing a couple of things. I'll tell you about the case we brought in a minute, but I think in the present moment, what you're starting to see is that the consent of the governed is breaking down, and it is incumbent upon the governor to stay ahead of that. You know, we don't want to have a situation here like we had over the course of 25 years with the enforcement, for example, of marijuana laws, where people are breaking the law, the rule of law just doesn't matter to them. You know, they're going to engage in certain conduct. When the polity withdraws its consent for draconian measures, it's incumbent upon the government to pay attention to that and catch up. People are tiring of the lockdowns. They're looking at the data. They're seeing, for example, that 70 to 80% of the deaths, depending on what county you're in, are happening in nursing homes. To David's nomenclature earlier, Michael's nomenclature, there are less restrictive, more tailored ways to do these lockdowns, and the people are starting to demand that. When you look at the governor's original orders, we brought a suit in federal court here in Philadelphia, alleging really two main things. First, that the taking of people's businesses, shutting certain businesses for the benefit of the public, is a taking under the federal Constitution. And you can't do that without compensating the people whose businesses have been closed and, importantly, whose jobs have been seized, right? The taking also extends to the jobs that were taken. Second, the manner in which the governor went about ordering closures was arbitrary and capricious, and it violated people's rights to due process of law. Basically, you can't say you close, you open without any rhyme or reason to who is opening and closing. And I'll give you some examples. The governor had a business, his family had a business that was in the cabinetry business, right? They make kitchen cabinets. They got a waiver and were opened. Many other businesses in that space did not. The president of the Pennsylvania Senate had a candy company that was given a waiver, and other businesses like it were closed. I have clients that are car dealerships They were ordered closed. Large chains of corporate car dealerships were opened. There was no rhyme, there was no reason to the way these businesses were opened and closed. The governor has been evasive about this. The Pennsylvania Senate served him with a subpoena, and the night before the subpoena response was due, the Inquirer reports that people were getting revocations and grants of waivers up until 9:30, 10:30 that night. They were trying to rearrange the deck chair so it didn't look quite so sinister. That is not permissible, and we're going to call the government to account for it.
So David, I'm curious about your perspective as someone who's not in Pennsylvania, but follows these things closely. What do you see happening in Pennsylvania and in other states that we might learn from? And is this kind of civil disobedience that Jonathan's referring to, if I can call it that, something that you see maybe expanding over the months, or where do you see it happening? Is the governor, not just in Pennsylvania, but in other states, which side are they going to be on this equation?
That's a great question, John. And I think, we do operate, as Michael said, in a system of federalism, and states can be, in the words of Justice Louis Brandeis, laboratories of democracy and approach things differently. What I fear, and this has happened in Maryland, and it's happened in a few other states, is that there's going to be a criminalization of the right to protest. And that is absolutely essential in a constitutional democracy or a republic, that people have to have the right to protest, that people have to have a right to voice their opinion and their objections to government actions that they find to be arbitrary and capricious. And I fear that what we are seeing in many states is a reliance on numbers that may or may not be accurate, and a swooping of governmental power under this sort of emergency exception, and the squelching of individual liberty. And I think we have to watch that very closely.
So let's talk a little bit more about assembly, and then go to really our political process, which has grinded to a halt in some places. And I don't actually know if any of you have been kind of working on any of these cases, but we see elections that are not happening. We don't have assembly in a large portion of the United States. We had a case in Pennsylvania that was ultimately dismissed by a candidate who was running and could not really run a campaign under these conditions. Does anyone have any thoughts on where is any of this moving through the courts besides that one case in Pennsylvania? Right.
So you're talking about the DeVito case,
I am.
Which was brought on an emergency basis. I think that was not prudent, and I think that the Pennsylvania Supreme Court dispensed with that case in a way that may have had a different outcome, and if it had been given some time to go through the trial courts and a factual record had been built. In terms of the election law aspects of this, I'm part of a task force actually right now looking at it. I mean, it's very easy for lay people to say, well, let's just snap our fingers and conduct our elections by mail. Well, wait just a second. We have a series of mechanisms in place for ensuring the integrity of our elections when they're conducted in person. And part of the goal is that mechanism, that set of mechanisms, is to make sure that the elections are in fact conducted with integrity, right? But the second goal of that is to make sure that it is done using a well-known process that gives the polity assurance and confidence that it was conducted in a fair and transparent manner. We know how to monitor an in-person election. When we suddenly shift to a mail election in the year of a presidential election that is at a minimum highly contentious, at a minimum, you run the risk of losing the confidence of the polity. Let me give you an example. What if now we're going to conduct the election by mail? If it were conducted in person and a person requested assistance in the polling booth, which they're allowed to do, we have a law that prohibits their employer or their union representative from being the person who assists them in the polling booth for obvious reasons, right? We're worried about undue influence. Now you move to a mail election. We send mail ballots to everybody's house. What if the person going door to door is their employer or their union representative? What if A Republican goes into a heavily Democratic area, or Democrats go into heavily Republican areas, collect those door-to-door ballots from households they know to be very much in the camp of the opposing party, and 8% of those ballots wind up in a ravine somewhere. We got to know who's doing the soliciting of those ballots. We got to know who's collecting those ballots. We got to know what circumstances. Can felons go around and collect those ballots? So we have a lot of work to do to make sure that the election is conducted with integrity and that it's conducted in a way that gives people the impression that it was conducted with integrity. Big, big, big job ahead.
So I'm sorry, go ahead, Michael.
No, I was just going to say, we are starting, I mean, this has been a theme throughout. Actually, just shortly ago, the Wisconsin Supreme Court actually weighed in and struck down the governor's stay-at-home order. But it's important, again, it goes back to my federalism point. That's because of the mechanisms within state law, for example. So you have both the federal constitutional provisions, like we've been talking about, First and Second Amendment, for example, that are a check, but you also have internal to the state, you have limits on the scope of the governor's power. And so that's where you're starting, I think, also to see some action that the either the governors themselves or the delegation of authority to health secretaries and things like that, that somehow the restrictions are overbroad and lasting too long in some instances.
So let's talk about federal power. There's several questions that all deal with travel and interstate travel. So it's shocking to me that we would even have this conversation, but here we are, and we have restrictions. I don't know that any of them really exist right now, but let's go back a couple weeks, at least not in the way they did, where we had police stopping people at borders in several states. We had people refusing to serve, meaning commerce, in some states. In the state of Delaware, this happened. Where are we here? What happened to the interstate commerce law? Why is this not a clause? And why is this an issue? And do we see this? Is this the end of it? Have we seen the end of that kind of issue? Michael, let me ask if you can start to answer that question.
Well, I guess I'll again take it at both the federal and state level. So I said earlier that the president is constrained by whatever power has been given by Congress. There is authority in certain public health statutes for the president to prevent different interpretations of this, but he could shut down the airlines, for example, could shut down interstate air travel, could shut down interstate travel altogether. And so I think there is something to that, but you're talking more, I think, about restrictions that states are imposing on people coming from out of state. Ordinarily, we would think that poses a problem under what we sometimes call the Dormant Commerce Clause, which is basically states can't unduly interfere with the flow of interstate commerce. But there again, we're back into the question of, given the circumstances, in some instances, for example, preventing people from New York for coming without self-quarantining or something like that, where at least there's a little bit of leash here for the governors in some states to act. A challenge to that, again, would depend on how reasonable the restriction was and how long it was lasting. States
in the past have been allowed to restrict in this way under prior quarantines and under sort of federal court jurisprudence. We've seen that. But there's a separate issue, which is this. If I cross the border into Delaware in my car and I have a Pennsylvania license plate, I don't believe that creates reasonable suspicion for them to stop me and pull me over. And in the event that Delaware state trooper pulls me over and I roll down my window and he says, "What are you doing in Delaware?" the correct response is, "Am I free to go?" Right? There's no basis for stopping me just because I have an out-of-state license plate. I'm surprised we have not seen more people asking, and if I were going to give any legal advice today, and I'm not giving legal advice, but it would be to keep that question of "Am I free to go?" right at the top of your list of things to ask if you ever have an encounter with the police, because if you're not free to go, they have to be able to articulate why you're not free to go. And merely being from another state, generally speaking, is not, merely having a vehicle from another state is generally not a sufficient basis. David or Michael, is that crazy talk?
So let me ask our professor.
Could be then, is what I'm hearing.
This is the difference between the guys who's got his practice in suburban Philly, right?
Right.
So let me ask you, David and Michael, from your view, give me a little bit of maybe hope. I hope you can give me some about a year from now, 2 years from now. So the last part of that quote I had was, so might restrictions that for reasons of political inertia, and I would say there would be lots of other reasons, I think this is a very kind way of looking at it, remained in place after they no longer be reasonably justified. In other words, could we see some of these restrictions continue regardless of what the crisis is? And I want you to maybe answer that from a historic perspective, right? Because we've seen this happen before. We've seen it in 9/11. We've seen it in World War II, World War I, the Civil War. We've seen restrictions that were significant. What happened afterwards? David, what happened after the crisis passed in those cases?
Well, it depends, so for example, if we take the 9/11 attacks, I think a mere 45 days after 9/11, we got the providing appropriate tools required to intercept and obstruct terrorism, the United Strengthening America Act, the USA Patriot Act. Some of those provisions had sunset provisions. Some of those provisions are still in law today. So I think that there is always the potential that certain principles can extend beyond times of emergency. Now, when we look at that, I think we do have to take a balanced and nuanced view. Let's take the Patriot Act as an example. There probably were there were some provisions in the Patriot Act that updated the 1986 electronic privacy law. I think the Patriot Act amended 17 different federal laws. The fact that we had different intelligence agencies not sharing information, some of the breaking down the walls of the sharing of information were probably appropriate. But the more draconian measures, somebody used the adjective draconian, reminds me of the Athenian lawmaker Draco from 621 BC, right? Some of these measures are simply too restrictive of individual liberty, and hopefully there are sunset provisions on these, and they will not have a lasting impact on our constitutional jurisprudence. I fear that when you allow the adulteration of strict scrutiny review, that government attorneys are going to be able to use that in future cases.
Michael,
As
your
if, by the
thoughts?
way, those government attorneys needed more help. I mean, from the doctrines of qualified immunity to all the deference they get all over the place. I mean, putting yet another thumb on the scale to assist the government in the expansion of its powers hardly seems like the right move.
And Michael, I know you've been involved in some of these, some of this work. What are your thoughts on whether or not we will see some of this continue?
Well, like David, it depends. It depends on the context and what we're talking about. There is a unfortunate sometimes tendency towards I guess a kind of overweening statism or people bossing other people around that sometimes people allow for. But you never know. I mean, one thing that Jonathan said that was interesting, talking about a takings challenge. As he knows, and I admire his courage in bringing those kinds of claims, but takings under these kinds of circumstances, takings claims are very hard to prevail on given current contours of Supreme Court doctrine and the limits on review of regulatory takings of this kind. You never know. There might be, especially if this goes on for a long time and lots of businesses start to suffer even more than they have already, you could start to see maybe in some instances courts being a little more sympathetic to a kind of regulatory takings argument than they have been in other contexts. But Jonathan knows a lot more takings law than I do. But that strikes me as an area where you could see a kind of pushback from the courts, from business owners over and against this kind of thing. But in other contexts, we have 9/11 is one example where a lot of the provisions that were put in place then, many of them for a good reason, I would say, as an alumnus of the Bush White House, I would say that many of them were warranted and still are warranted given the state of the world today. But then other restrictions, say on freedom of speech, for example, in World War I and in that era that were in place are now very much sort of dark mark in our history constitutionally. So also with the sedition acts from the early republic. So there have been kinds of restrictions like this historically that have been put in place that we judge now historically very darkly because we think that they were unduly restrictive and were really contrary to the best of the American constitutional tradition.
You know, John, one notion, if I might dovetail off of what Michael said, the courts have allowed a lot of things over time, right? They've made takings cases very hard to win. They allowed us to imprison Japanese Americans during World War II. You know, they allowed Dred Scott to be treated as property. Just because a court allows something doesn't make it right. And for the governor of Pennsylvania to put 2 million people out of work in the course of 3 weeks, just because the courts sign off on it and say, gosh, golly, it was an emergency, we're going to let that slide, that doesn't make it right. And it doesn't make it a sort of thing that the polity ought to stand for. And we ought to be standing up on behalf of our fellow citizens and saying this has to stop. We have to find a way to more narrowly tailor this. We have to accept the data that are being published about where these very serious infections are occurring, very deadly infections are occurring. We have to find a way to tailor this now 6, 8, 10 weeks in a way that doesn't kill us all.
So let me get to a few questions. We have lots of questions and a few of them are really very good. A lot of them we've actually already covered, but here's one. Does the Constitution or federal statute give the president the right to supersede state police powers when the president declares a national emergency?
Basically, no.
Unless he has some kind of express authorization from Congress, which again, in limited context involving the public health laws
Right.
and things like that, he has some power. Congress could tomorrow pass a law that gave the president broad preemptive power over the states because almost anything can fly under the Interstate Commerce Clause, and
Right.
and this clearly implicates that. It could give the president broad preemptive powers to override state shutdown orders, but I don't think that's likely to happen.
The more interstate the nature of the conduct the president attempts to regulate, the more firmly grounded his authority is.
So I don't know if this will be my question. That's similar, I think. War Powers Act. We've heard the president at least once or twice talk about that. Can someone explain what it is and how it might or might not be relevant to this?
Fundamentally, I think we need to have a war to be having war powers. I think we still are in a declared war, though, aren't we? Are we in the war on terrorism still, guys?
Doesn't the Senate have to do that, Jonathan?
Congress is the one traditionally that's thought to be the one to declare war, although
All right,
in the modern era.
we're getting all over the place. Let me come back.
Well,
So War Powers Act, no, because it's been discussed. Someone tell us what the War Powers Act is.
But do you mean the Defense Production Act?
Defense Production Act, forgive me.
Separate issue, yes.
Sorry,
There's the War
forgive me.
Powers resolution
Yes.
from the Vietnam era about Congress's power to basically override or at least interfere with the president's decision to commit troops to war.
Right.
The Defense Production Act is a 1950 statute that gives the president the power pursuant to certain national security aims, basically to commandeer industrial power for purposes of national security. And so you saw the president invoke it, I guess, first kind of in a generic way, and then in a more limited way with regard to manufacturing ventilators. Actually, the meat production also, there was an effort delegated to the Secretary of Agriculture to keep meat plants open under the Defense Production Act. But that's basically what the authority is that for purposes of national security, the president under this grant of power from the Korean War era can sort of commandeer industrial production.
Governor Wolf actually invoked a state level power that was similar, attempting to commandeer the production of masks at one point several weeks ago. I haven't heard much about it since, but he did, in his flurry of executive orders that get issued every few minutes, it would seem. There was one in there about everybody who makes masks has to give them to me, sort of thing.
So here's a question, and it's really about the security versus liberty. I fear that government wants to prematurely open up the country or states in hopes to keep the economy and businesses alive. However, there are so many people who are not taking this seriously. It seems like Jaws. Beach is open when there is still danger. How can we find a happy medium where protections are enforced, but businesses can open? I guess we can answer this in a couple different ways. Is there a legal answer to this, to that kind of question?
Really
It is
more
a,
of policy.
go ahead, Michael, please.
It's more of a policy question. It has struck me throughout these several weeks now that we have a hard time sort of thinking in terms of reasonable trade-offs between what we know the risks of the virus and the devastation that's being wrought on the country economically. And I only have one citizen's view on that, but it strikes me as more of a policy issue than a straightly legal question.
It is an utterly false dichotomy. It is a false division to say that it is lives or the economy, right? What we now know from lockdowns happening all over the world is that there are health impacts to the economic impact. You know, there was an article in one of the foreign papers a few days ago that in Africa, they're seeing a massive resurgence of TB cases. What does it mean when a woman in this country detects a lump in her breast and puts off a cancer screening for 8 or 12 weeks and now has metastatic cancer? What does it mean when a man cancels a colon cancer screening? What does it mean for a child in foster care to stay in that system for 12 extra weeks? What does it mean for all the school children in Pennsylvania to have 5 to 10% of the schooling they're ever going to receive be canceled, right? There are definite well-being and health impacts to what is perceived to be an economic shutdown. We have got to find a way to protect vulnerable populations the way they have in other countries and simultaneously protect the economy, because good economic outcomes are highly correlated with good health outcomes.
So, gentlemen, have we seen any legal challenge on that medical issue for people trying to get medical treatment that can't? Have there been any legal challenges to shutdowns of health systems?
Well, in the abortion context, in some states now, when governors, there was a prominent case in Texas a few weeks ago where the governor shut down all elective procedures. It wasn't targeted at abortion, but it was targeted at any elective procedures. And there was a challenge brought to that. There have been some other states that have had this similar cases. There might be cases for all I know, but that's certainly been the one that's been most prominent over the last couple of months.
One other problem we're seeing is that there's been attempts to release medical information as to who has the virus and the release of private medical information. And that raises a whole host of thorny privacy issues, right, under HIPAA and other laws. That information could lead to a host of, public disclosure of private facts, tort suits. And so it's just raised so many more problems than I think we initially realized.
So David, I had read that there is a process by which healthcare systems can now kind of track all of that in a different way, or there's the potential for that. Maybe you're referring to some of those things, and making that information public to, or at least available to other systems and things like that. Is that what you're referring to? That kind of private information about COVID, whether you have it or not? And what kind of issues do you see happening legally, and have there been any challenges to those kinds of things?
I don't know if there have been any lawsuits yet. We've seen in our headlines down in Tennessee a fear that there's been the release of private medical data. And of course, the release of private medical data does raise sensitive privacy concerns. When we talk about privacy, of course, it's important to separate the constitutional right to privacy under various amendments or penumbras, as Justice Douglas said. There's a lot of statutory rights to privacy, but then there's also the common law tort protections of privacy. And if someone releases someone's private medical data, that potentially could violate some statute, but it certainly could give rise to a common law tort action for invasion of privacy.
I will say on this HIPAA issue and access to healthcare, I think somewhat happy story in a limited way is that the HIPAA statute, which the Department of Health and Human Services is charged with enforcing, has all kinds of strictures and regulations on it, and many of which were, at least as interpreted by healthcare providers, preventing widespread use of telemedicine. And so as a result of that, there is a kind of great fear of going into the telemedicine market in any kind of robust way. But early on in this, HHS directed that those regulations basically be kind of relaxed. And that's why you've had more telemedicine, which I actually think in terms of healthcare delivery for the long term is probably a good thing and reduces cost overall.
I mean, we will have some positive learnings that come out of this about, social resiliency. We will have some things like telemedicine that maybe will be a little more robust. Cyber schooling is certainly, breaking loose in a way that would have been very difficult to do legislatively without a crisis like this. So it's not all bad news, but we really do have to find a way to get more tailored about this quickly, or we're going to have some really colossal problems that are going to be hard to undo from a civil liberty standpoint and from an economic standpoint, I fear.
So gentlemen, as we begin to wrap things up, let me ask you to look forward in first of all, Pennsylvania. And I think that we're kind of an interesting state in this way. Where are we going to be? And I'm going to make the assumption that we're going to see the continuing decline of numbers in terms of cases and things like that. Where are we going to be by the end of the summer? And I'm going to ask this from a personal property and business perspective. And I'm going to start with Jonathan, because I know, Jonathan, you've been working a lot on this. But where do you think we're going to be in 2 months?
So I'm very hopeful that deaths will be down, that infections will be down. This is a serious disease and it threatens lives. And I'm hopeful that it will attenuate by the end of the summer. And I hope we won't see a second resurgence in the fall. I hope that the fact that these viruses tend to mutate and become less vicious when they mutate, I hope that will be the case. From a property rights standpoint, we have to be open. We have to find a way, a tailored, careful way to get Pennsylvania back to work, to get businesses opened again, and to relieve some of the tremendous suffering we have created before it creates a structural devastation that we're unable to repair. I am hopeful that the governor respects the unrest that he is starting to see in the polity. I hope he will not again threaten Pennsylvanians who are just trying to earn a livelihood. I hope he will not again call business owners who are trying to save their life's work cowards, as he did the other day in a press conference. I think that is not gubernatorial. I think that is not becoming of an elected official. There's genuine suffering, and I hope we find a path to saving lives and alleviating that economic suffering, and quick.
And David and Michael, do we see something coming out of this that's going to change some law? Do we have some constitutional issues that are so big coming out of this that it could actually percolate to being a case that is going to be looked at as precedent for many years and maybe decades to come? Is there anything out there or issues that might look like that in a couple of decades?
Well, I mentioned before that you could imagine, if things unfortunately get much more extreme, you could imagine some revisiting of some of the takings doctrine and the way in which takings claims are just very difficult to prevail on, as Jonathan knows well. And in the area I work in a lot, I do think that with regard to freedom of religion, I think there, as we talked about a little bit, I think there's you're starting to see some courts enforcing seriously this idea that if you're going to exempt certain kinds of uses and deem them essential, that you can't treat religion in a less favorable way. And one other that I'll just kind of throw out there that there's unlikely to come to maybe much of a head at the Supreme Court, but under the CARES Act, the fact that there's provisions for payroll protection, there's a piece in the Washington Post today that is criticizing the fact that some of that salary supplement can go to churches and to religious institutions people saying that that somehow this raises constitutional problems. I don't believe that myself. I think if the government has a generally available benefit aid program that to cover payroll costs, that can go to religious institutions just as well. But it does kind of show another area in which the doctrine is evolving right in front of us.
I think it's possible we could start seeing more state constitutional individual rights claims being asserted. You know, for many years, sort of state constitutional law has taken a backseat to federal constitutional law. We had sort of rekindling of state constitutional law back in the mid to late 70s, primarily with Justice Brennan, I guess, disagreeing with the decisions of the Burger Court. But I do think as lawyers bring more challenges, in some states, there really is a dearth of the development of state constitutional law from an individual rights perspective. And I would imagine, and we've started to see this in certain areas, I think we could see an expansion of state constitutional law in this time period.
Gentlemen, I thank you for what was a wonderful discussion. I have to say I learned a lot. I hope our audience did as well. I wish you all of the best in the great work that you're doing at your schools and in your practices. And again, I thank you, and perhaps we'll reconvene this maybe a year or two from now and see where we are on these issues. I wish you all the best. And again, thank you. Thank you so much.
Here's to hoping we're not in lockdown if we reconvene.
Amen. Amen. Again, thank you. Our next program will be next Wednesday, where we will have Attorney General of Pennsylvania, Josh Shapiro, who'll be talking COVID-19 crisis from his interesting perspective. That program will be at 5:30. We're going to change the time to 5:30. And I think most of our programs going forward, we hope to make at 5:30 as well. Again, thank you, gentlemen, and to everyone that joined us. We appreciate you being with us, and we'll see you next Wednesday at 5:30. Thank you. Good night. Guys, if you want to hold on for just a